start this. So welcome those that have logged in. There's a few other people that will be joining us as the time goes on. The agenda for this is first, my name is Tasha Jones, and I am the Elder Abuse Prevention and Awareness Program Specialist here at Connections Area Agency on Aging. And in lieu of the COVID-19 pandemic, we are doing virtual trainings instead of the in-person training that most people are used to in our communities. So this is our final session in our series. And so we have Matt Bollman with us, and I'll do a quick intro in just a little bit. Some quick housekeeping for those that aren't familiar with the GoToMeeting is everybody is muted. Or will be muted, everybody but myself right now, just to get some background noise taken out. There is a question chat box. It looks like a little bubble. If you do have questions, please type them in there. And Matt had graciously said that we can answer questions as they come up, so please don't hesitate to wait to the end. We will just ask them as they are pertinent to the information. And then the certificate of attendance and a survey will be sent out probably early next week, so that way people have those as needed. So this is again in coordination with World Elder Abuse Awareness Day, which is today. It started in 2006, and it is an opportunity for communities all around the world, not just Iowa, not just United States, but worldwide, to promote a better understanding of abuse and neglect in our older people and raise an awareness for the cultural, social, economic, and demographic processes affecting elder abuse and neglect. So again, we have decided to do an online training opportunity. If you are familiar with the Council Bluffs, Omaha area and our central region, we were able to get the Bob Carey pedestrian bridge lit up purple, which is really super fun. It is a way for us to connect, Omaha and Council Bluffs as we partner with that area agency on aging often, that we can come together as a community, raise the awareness, and just keep that conversation going. And then on social media, on our Facebook page, as well as other AAAs in the state, tagline engage to prevent, and then our WEAAD 2020, as you'll see lots of stuff between today and the rest of this week, because in Iowa we were able to get the governor to proclaim it's World Elder Abuse Awareness Week and not just a day. So we are pretty thrilled about that. So with our series that we had talked about, we had Barb on Wednesday last week talk about what is dementia, the different forms of it, to talk about the increased risk that people have. We had Acacia with the Alzheimer's Association talk about communication, how to do that effectively to lessen the stress on the person with dementia as well as the caregivers, and just us as professionals and how to engage with both parties. So the other key component in order to protect individuals is going to talk about the legal side of things. So we have found that just in general, older adults are less likely to have a will. They know it's important, they just don't do it. I preach it often that we should do it, and I can't honestly say that I have it done. I know how to do it, but and then nearly 1 in 5 people said that they don't have an advanced health care directive either. So again, 60% of people say it's important to have a plan, but they don't have it set up. And that causes a huge barrier just in general aging, but then when we add in, somebody with dementia or any form of it, it has a heightened risk of not being able to plan accordingly and have them be part of that as well. So 5.8 million people are living with Alzheimer's dementia in the US. In a 2009 study, a little dated, that close to 50% of people with dementia have some kind of have experienced some form of abuse. Oftentimes we get calls at the agency for financial exploitation. We have family members that say they want to help, they have good intentions, but they do take advantage of a person with disability with dementia. So we have Matt with us. He is an attorney with the Pearson Bollman Law Firm in Des Moines. And he grew up in Northeast Iowa. Upon graduating from University of Denver College of Iowa in 2000, he moved to Seattle, Washington, and then to Phoenix, Arizona. So he kind of traveled a bit. And then he moved back to Iowa in 2008. So as you can see here, that Matt practices focus on estate planning, probate, trust, administrative, and elder law. So he seems, he's a great candidate to talk about how do we prepare our individuals, how do we educate our loved ones, those that we work with, and as well as their caregivers, on how to effectively plan for the future, and then the heightened risk that we run into with a person with dementia. So I am going to unshare my screen here somehow. Trying to figure out how I did that earlier. Oops, I totally unshared that. So, hold on. Now I gotta find my people. There. All right, so Matt, I'm gonna have you be the presenter, so you should be able to share your screen in just a bit here. There we go. And again, use that chat box if you guys have questions. I will review those and we will ask them as they come up. So do not wait until the end, and we will just kind of go from there.
So you can see my screen at this point?
We can see your screen, yes.
So I've got this go to meeting box that's in front of it. But anyway, as Tasha said, my name is Matt Bollman. I'm an attorney at Pearson Bollman Law. The focus here is on elder abuse. Just in general terms, I'm going to talk about estate planning. I'm going to talk about elder law is what we're generally talking about here. And okay. Just a little bit about us. Just generally, again, I grew up in a small town in Northeast Iowa called West Union. I went to UNI, graduated a degree in economics. From there, I went out to Denver, then out to Seattle, then down to Phoenix. About 12 years ago, finally moved back to Iowa. Lived just a little bit south of Des Moines with my wife and 2 kids and 2 dogs, and then have this law practice. Pearson Bollman Law is relatively narrowly focused as far as practice areas. So we do estate planning. So that's wills, trusts, power of attorney documents. We do probate trust administration. So that's advising, somebody's passed away. That's advising the executor or the administrator through the probate process, or advising the successor trustee through the trust administration process. And then we do practice a fair amount in this elder law area. So generally for us, that's guardianship conservatorship work. So that's maybe somebody who didn't put the right financial and healthcare power of attorney documents in place. We need a substitute decision maker. We're looking to the court system to appoint somebody. We do Medicaid planning, VA pension planning, special needs trust, supplemental needs trust. We do litigation specific to beneficiary representation or will set aside or trust set aside cases. And then we also do the regular personal injury, civil litigation stuff. We do have 5 offices. We've got an office in West Des Moines, Marion, Dubuque, Bettendorf, and then Okoboji. Currently, there's 7 attorneys and then 10 other non-attorney team members. So the agenda, again, how to prevent this elder abuse, I guess in my mind, starts with making sure you have all the correct documents in place. So walk through a checklist of, I do have all the documents that are critical in a will-based estate plan, or I do have everything for a trust-based estate plan set up. Then it's a discussion of, is a will the best route for your family, or should you have a trust? And then just some other things to think about when talking with your spouse or family members, financial advisor, whoever you're bringing into the loop as far as, setting up your estate plan. So that's kind of my traditional estate planning discussion. From there, we shift gears to that elder law area where, we're usually trying to protect assets against long-term care costs. How's it going to be paid for? Qualifying for Medicaid, qualifying for the VA pension. So the estate planning checklist. I visit with a few people every day, and inevitably, at least once or twice a week, I will visit with people who've been to an estate planning attorney, maybe just in the last few years, and for whatever reason, they do not have all the documents you should have in place. So when you dust off your binder or portfolio or wherever you're keeping these documents, what you're looking for is either a will-based estate plan or a trust-based estate plan. Within that document set, you should also find a financial power of attorney, a healthcare power of attorney, and a living will. And we're going to walk through each of those. So the financial power of attorney document, just critically important while you're alive. It's effective only while you're alive. So it's basically the substitute financial decision maker. So you lose capacity, who can make financial decisions moving forward? There was a new Uniform Power of Attorney Act passed sometime July 2014. So, if you have an older power of attorney document that hasn't been updated since, it would probably be a good idea to go back in and update those so that it's at least on a new uniform form. Kind of the biggest area that we see potential issues with, decision making related to, hey, I do want a substitute decision maker. How do I do that? The correct way to do it is to document it in a financial power of attorney. We oftentimes see people go to the bank and say, hey, I want my son or daughter to be able to write checks on my account. How do I do that? And instead of getting the good advice of, well, just, list them as your agent on your financial power of attorney, they instead might make them a joint owner on that account. Joint ownership on your bank account has many issues. For example, if you had this son, Jerry, and you named Jerry as a joint owner on your account, what happens if Jerry gets a divorce? You're going to lose half your assets to Jerry's ex-wife. What happens if Jerry gets into a car accident and he's sued? Again, it exposes that asset to Jerry's creditors. Then what if Jerry predeceases you? Then you have nobody to act in that role of substitute decision maker. So make sure that you've got this financial power of attorney document set up. You also want to make sure as to when it's effective. Sometimes they're effective immediately. Sometimes there's a requirement to have a physician say you don't have capacity in order for it to be used. So, make sure you understand that. And then, with all of your estate planning documents, it's really something that you should revisit every few years. Who have I named as my healthcare agent, or who have I named as my financial agents? Who you name today might not be the best person in a couple of years. Maybe their family situation or financial situation changed. So this is something that you should always be revisiting as to who you name in these documents.
So Matt, you had mentioned that not to do like a co-ownership.
Yep.
With our elders, that we often find that they would like to have somebody help sign their checks or to help manage the finances if they can't make it to the bank. What would you recommend instead of the joint ownership then?
Get your financial power of attorney document on file with the bank so that they know that you have a substitute decision maker. Have that document effective immediately. And more than likely, they will just put them on as an authorized signor.
Okay, so an authorized signor rather than a co-owner.
Right.
Okay.
The other issue with adding somebody as a co-owner is, let's say that you have 3 kids. When you pass away, that account becomes owned by the other co-owner, the remaining co-owner. And, I know that people say, well, I will certainly split it with my siblings at the point you pass away, but that never happens. It never happens. So, don't use co-ownership. Just continuing on with the financial power of attorney. This is how you and your family avoid conservatorships. So, if you do not have this financial power of attorney document in place, you, for whatever reason, put it off, and then you lose capacity, you can't put a financial power of attorney in place at that point. It's too late. That's where your family would have to bring you into the court system effectively and set up a guardianship conservatorship where the court is naming who the substitute financial decision maker is going to be. The issues with it are, there's annual court reporting. It's relatively expensive to set up. When you do this financial power of attorney, you're the one making the decision as to who you want to be your decision maker, hopefully providing that opportunity to avoid that financial exploitation. Because if it's, up to a conservatorship proceeding, maybe somebody who you wouldn't trust or wouldn't want in that role is the person being named, because they're the ones that hired the attorney to petition to be named that role. Healthcare power of attorney, again, it's the unable to make healthcare decisions for yourself. Who's going to make those decisions for you? We oftentimes see people who they've got the documents in place, but for whatever reason, they didn't take them to the hospital or clinic to have them scanned. In my opinion, your agent, the person that you've named as the substitute decision maker, they should also have a copy of it. We like to put phone numbers on it so that, that oftentimes utilized in emergency situations. And then make sure that it has the HIPAA medical release information form. So this is, again, something that if it hasn't been updated in, 5, 8, 10 years, it's probably a good idea just to make sure that they're updated, that they're on the most up-to-date. Usually they're on the Iowa Bar Association forms. And then a living will. So the living will say, if death is imminent, I do not want life-sustaining procedures performed on you. Oftentimes, attorneys utilize the Iowa Bar forms, and the living will and the healthcare power of attorney are sometimes on the same form. So don't let that be confusing. Again, make sure you take it to the hospital or clinic so that they have it on file. So should you have a will or should you have a trust? Very popular question these days. Both of them are designed to do the same things. Both of them are designed to distribute your assets to who you want, when you want, how you want. But there are two big differences. One of the big differences is when they become effective. A will-based estate plan really does not become effective until after you pass away. Whoever you've named as the executor in that document is going to take the will, the original will, to an attorney. The attorney will do the opening probate paperwork. They file that with the court. That's when the will becomes effective. Whereas a trust becomes effective just as soon as you sign it. It creates a new legal entity at that point, an entity that can own assets. So when they become effective is one big difference. The other one is how they're administered. A will-based estate plan is administered through the government-supervised system of distributing your assets called probate. Whereas trust administration generally is designed to be handled outside of that setting. It's handled in a more private family setting. So all of the trust administration probate paperwork isn't flowing through the courthouse. So again, two big differences: when they're effective, how they're administered. I always have people who say, well, I just did a new will. I thought my estate was going to avoid probate. And that's not the case. A will is effectively instructions on how your assets should be distributed. It's designed to go through the probate process. So that's sometimes misunderstood. Will-based estate plan, again, equals probate. Some of the issues that people oftentimes have with will-based estate planning are as follows. So everything that flows through the courthouse is public information. So if your estate is passing through probate, all of it, anybody can go to the courthouse. They can take a look at your will. They can take a look at your inventory. They know what you had. They know who it's going to go to. some families just don't want that intrusion into their business. So privacy oftentimes is an issue with probate. The probate process is very paperwork intensive. There's all kinds of required filings. For whatever reason, it seems to take a long time to sometimes get an estate open and oftentimes longer to seemingly get closed. So time is oftentimes a point that people raise as, I don't want my beneficiaries going through probate because it takes too long. And then the last, and usually generally the biggest reason as to why people want to avoid probate are the cost aspects. So cost-wise, the costs are statutorily defined. The statutory maximum an attorney can charge to probate an estate is 2% of the gross estate value. So that's everything in your estate except for life insurance. So even if something has a beneficiary designation, payable on death, transfer on death, even if it's being controlled by those designations, still listed on the inventory, executor's fees still charge off of that number. Court costs are around 0.2 of 1%, and then attorney's fees can also be the 2%. Again, the 2% is a statutory maximum. You know, your executor can negotiate that fee with the attorney, but you know, sometimes that's not always understood. So, you know, for example, on a $500,000 estate, that would be approximately $10,000 in attorney's fees, 10 grand in executor's fees, about $1,250 in court costs. So when people are looking at trying to avoid that process, that's when they shift gears and move to trust-based estate planning. Again, designed to avoid that probate process. Privacy, all the paperwork isn't flowing through the courthouse, so it's not public information. There's far fewer steps because we're not having to do, the attorney's not having to prepare all of the probate paperwork. And then the fees just generally, usually the attorney's fees are either charged on an hourly fee or they're charged on a lower percentage of the gross estate value. And then you're avoiding all the court costs because it's not flowing through the courthouse. So those are some of the differences between will-based estate planning and trust-based estate planning. It's really just whatever plan is going to work the best for your family. And then it's revisiting to kind of avoid this, families staying together after mom and dad pass away. You know, you don't always have to put the oldest, son or daughter in that role of executor. You know, it's a skill set that you want to line up for that job. You know, and accounting is going to be required. A tax return is going to be required. You know, who's the best fit in your family for that? Or, let's not even name somebody in the family. Let's name a bank trust department, a corporate fiduciary to act in that role. So some things to think about there. So who's best suited for a will-based estate plan? Again, for starters, it's always good to have something. At a minimum, make sure that you have your financial power of attorney, healthcare power of attorney, living will put in place. Those are relatively inexpensive to set up. Generally, a will-based estate plan is a less complicated estate plan. So sometimes people just like the idea of, I just want to name where things are going to go. I don't want to deal with it. I'm just going to have a will. Excuse me. And then, if your gross estate value, if you've got a house and, 100 grand or so, it might not make financial sense to set up a trust-based estate plan because normally a trust-based estate plan is going to be set up, is going to cost more to set up than a will-based estate plan. So, that financial piece always has to play into it. But I've had people who've had relatively low gross estate values, but they're just like, I don't want my estate to be public information. I've got this privacy issue. So for that reason, they set up a trust-based estate plan. So you just need to understand the pluses and minuses of both, the financial aspects of it, and then figure out what's important for you and your family. Who should have a trust? Again, I kind of just approach this from, trust-based estate planning in my mind is you, the person trying to organize your estate today to make things easier to administer at the point you pass away. Again, we've got that You know, potentially the people are concerned about privacy. It is usually more expensive to set up than a will-based estate plan. But the idea is that you're going to recoup, or the family's going to recoup those expenses as far as the administration side. Excuse me. The one critical piece of trust-based estate planning is it's a more complicated estate plan, and you need to make sure that all of the assets have a plan. You know, that they are controlled. They're either titled in the trust, have a beneficiary designation, payable on death, transfer on death designation. So that's kind of one of the big issues with trust-based estate planning is understanding how it works. Other items to think about when talking with your spouse, when talking with your estate planning attorney, your financial advisor. We include beneficiary protection trusts in all of our documents. You just do not know what your beneficiaries are going to look like at the point you pass away or the condition that they're going to be in. So we always include a supplemental needs trust, an underage trust, incapacity trust in all of our documents. So this would be at the point assets are being distributed, that executor is looking at, you know, am I distributing assets as somebody who became disabled and receiving needs-tested government aid? If so, I want their share held in trust so that they don't get bumped off of that aid. You know, have one of my children passed away and now assets are being distributed to a grandchild? If so, you probably don't want assets distributed to somebody that's underage. And then incapacity, you know, drug, alcohol, otherwise doesn't have capacity. We want to make sure that those assets are being protected so that they can't potentially hurt themselves in those situations. The lifetime protection trust is kind of an optional one, but that's, you know, I've got a child that potentially has a spendthrift problem. You know, do you want them to receive an outright distribution and have all the money gone in a few years? You know, probably not. All of those things above can be set up either in a will-based estate plan or a trust-based estate plan. In my opinion, you know, you want those beneficiary protection trusts in all of your documents. They may never be used, but like I said, you just never know what your beneficiaries will look like at the point you pass. I'm going to drive into that supplemental needs trust a little bit further, but, you know, this is, you know, let's say that you have a child that has autism or, you know, for whatever reason, potentially disabled. You know, you certainly want to include them in your estate plan, and the appropriate vehicle would be to place their assets into a supplemental needs trust. So it's designed for somebody who's on Medicaid or means-tested government program to be able to receive resources that supplement their lifestyle, but doesn't bump them off, you know, Medicaid or whatever means-tested program that they're on. The nice thing about you setting it up is that it's characterized as a third-party supplemental needs trust, always remains non-countable for that Medicaid applicant, and then there would be no payback provision to the state of Iowa. At the point they pass away, it would just pay out to the other siblings or whoever the remainder beneficiaries are. Underage trust, again, that's the situation generally where, you know, one of your children pass away, assets are going to your grandchildren, you know, depending on their age, their assets might be held in trust for their benefit. We normally define underage as age 25. Instead of having this requirement that the guardianship conservatorship be set up and then that grandchild just gets the assets at age 18. You know, we all remember when we turned age 18 and what we may have spent the money on at that point. So it's just, you know, it's wise to maybe have it managed for a period of time a little bit longer. And then the incapacity trust, again, usually the situation we're thinking about would be, you know, a beneficiary has a drug or alcohol problem. You know, we want those assets held in trust so that, you know, potentially it doesn't, you know, promote them, their substance abuse issues to become worse than what they were before. with more resources. Again, lifetime protection trusts. Again, we're, trying to avoid creditor protection issues, divorce protection, things like that. Other items to think about. Doing estate planning is complicated. I mean, not only do you have to look at it from the legal framework, but you need to understand and usually work with the financial advisor to make sure that everything is coordinated and everything has a plan to where it's going to go. IRA money, qualified money, 401k, those types of assets are always going to be controlled with the beneficiary designation form. So, you need to make sure that you're either pointing it back through the trust or that you've got named beneficiaries on that money. Business farm succession planning. We live in Iowa. We work with a lot of farmers. The farming situation generally is one of the kids stayed back to farm, two of them moved off the farm. We're really land rich, cash poor. How do we treat everybody equally? We can work through those situations, whether it's putting a buy-sell agreement in place, second to die life insurance, we would figure something out. Is client worried about their spouse remarrying and disinheriting children? My favorite story about this is I had an older couple over in Marion that I think he was 88 and she was 86, and she was just convinced that if she passed away before her husband, that he was going to marry the woman down the street and disinherit their children. If it's a concern at age 86, it will always be a concern, but it can be very easily addressed in estate planning documents. So, the point of that is that you need to know what your issues are, what your goals and concerns are, and bring those to the table when talking with your estate planning attorney. And then who are you naming as executor or successor trustee? Again, this is that topic of, it doesn't have to be the oldest child. It doesn't even have to be one of your kids. Our kind of, fastest growing practice area is this area of litigation, related to elder abuse or related to beneficiaries not getting along after mom and dad pass away. So, maybe take that decision making outside and use a bank trust department as opposed to using one of the kids. So, again, just something to think about. And then the last bullet point on here is estate plans are not static. You need to revisit every few years what's going on. The person that you named as the executor 5 years ago might not be in the same spot today, and it might not be the best person. Family dynamics change, financial situations change. So always be reviewing the documents. Kind of just a summary of the traditional estate planning, make sure that all the documents are in place. Again, I visit with a lot of people who've been to an attorney. I would say 1 out of 4 are missing one of the power of attorney documents. I don't know why that is, but it happens all the time. Visit with an estate planning attorney that walks you through the discussion of, should my family have a will? Should we have a trust? At least have that conversation. Coordinating beneficiary designation forms, that's working with an attorney and the financial advisor to make sure that both are on the same page as far as how this plan's going to work. If you do decide to do a trust, make sure that it's fully funded, and then revisit that plan to ensure all roles are filled with the right person or bank trust department. So that's my traditional estate planning discussion. I don't know if that prompted any questions or not. I don't know if you're still monitoring them or not, but anyway.
I don't have any questions at this time.
Well, it's just because I'm explaining it so well, right?
Well, a lot of times we do talk about the power of attorney forms when we meet with anybody because we know it is important. We don't provide that legal advice by any means, but we at least initiate the conversation. I think the rest of it that you're going to talk about is really the questions that we have for the long-term planning, and how do we know when it's too late, or what to look for in that aspect.
Okay. Well, and some of these slides are relatively general. So, depending on how far you want to get into the weeds, I'm happy to do that. But what I'm going to talk about is asset protection from long-term care costs. So here I'm talking about Medicaid planning, and we're talking about pre-planning. So this is, generally my clients in this situation are, let's say they're in their mid to late 70s, both, relatively healthy. There's no imminent, I'm moving into a care facility tomorrow, but they're concerned about, potentially leaving some assets to the next generation. Some have purchased long-term care insurance, some haven't. The next situation is crisis planning. This is where usually it's, you're the spouse living at home. You just moved your husband or wife into the care facility, got your first bill for $7,000, $8,000. What am I going to do? It's really kind of the most rewarding cases I work on, because I know how stressed out that spouse at home really is, and we help them out all the time. VA pension planning. We utilize this quite a bit. It's a VA pension that people might not know about, but at the time a vet or spouse starts receiving home care or moves into assisted living or long-term care, definitely something that could be utilized. Again, might not be for your clients or yourselves, but could be for your parents. Everybody's kind of interested in this. Statistic-wise, 69% of all Americans over the age of 65 are going to utilize some type of long-term care during their lifetime. The average cost of long-term care in Iowa is $80,000 a year. Average stay is 3+ years. You do 3 years times 80,000, it turns out to be a big number. Where's that money going to come from? There are only so many places that it's going to come from. The first one I would characterize as your best option. If you or your family is in that situation where you can purchase long-term care insurance, it's going to be used for exactly what it's designed for. Excuse me. I just think traditionally it's just been a hard product for insurance professionals to sell. I think people are looking at it from a, I don't want to pay in premiums for 20 years and then I die of a heart attack in my sleep and I never get to use it. And the insurance industry has sort of recognized this, and they've moved from just the pure long-term care insurance that was kind of this use it or lose it proposition to these hybrid products where it's based off of a life insurance product or an annuity product, where even if you don't use it, it's still going to pay out a benefit to your beneficiary. So, again, we always point people to, let's look at insurance as an option for you first. But, many of my clients, either age-wise, it just doesn't make financial sense, or health-wise, they can't be underwritten. What are the options at that point? The first one here is self-insure or pay privately. But again, if you're the spouse at home that you've got the house, you've got 250 grand in the bank. I mean, as soon as you get that first bill for $8,000, you don't know how long your spouse is going to be there. So, that's a concern. So we look at qualifying for Medicaid or qualifying for a VA pension. So with Medicaid, the first big rule that we generally talk about is this. It's asked on every Medicaid application, have you made any transfers within the prior 60 months? And if so, were they gifted, were they, transferred for less than fair market value? Were they gifted away? Ideally, the client is saying no and no on that. But there are major exceptions to this rule. So there are unlimited transfers to a disabled child. So if we've got a husband and a wife who have a disabled child, they can transfer assets to that disabled child in order to get below the Medicaid numbers, and they're not going to be penalized for that. Always concerned about, well, okay, does this transfer to the disabled child? Is that bumping them off some type of program they're on? So that always needs to be looked at and considered. Caregiver child. This is an oftentimes used exception here. So, has your child been providing care to you in your home for the prior 2 years, and but for that care, would you have needed nursing home care? If this is normally supported with a physician statement, but that's oftentimes a great way to preserve the family home. Transfers between spouses. So, I mean, there are so many misconceptions about Medicaid planning, and I think one of the big ones is, okay, my husband or my wife just moved into the facility. I need to spend down all of their assets in order to gain Medicaid eligibility. That's not the case. You could literally transfer all of the assets to the well spouse. Now that the applicant spouse has their less than $2,000, and then we need to figure out how much to spend the well spouse down to. But transfers between spouses are always allowed. And then lastly, transfers to purchase exempt items. Both the Medicaid policy manual and the VA pension policy manual have a list of exempt items. Why not take countable assets, purchase exempt assets, and make them non-countable? That's what people hire us sometimes to do, to advise them on, well, what is exempt? So the first situation, again, that we oftentimes work with is this proactive planning situation where, people have this, concern, this kind of cloud hanging over them of, if me and my wife move into a care facility, I'm going to lose the family farm or, my house or, whatever they're trying to protect. So we know that we've got this 5-year look back period on the transfer of assets. So if you transfer it within 5 years of trying to qualify for Medicaid, DHS is going to penalize you. So people are trying to get that look back period started. So in those situations, they're looking at transferring assets, getting them out of their name, so that if and when they ever need to gain Medicaid eligibility, that those assets, it would have occurred 5 years or longer. So in those situations, we're recommending clients to transfer assets to an irrevocable trust. We recommend an irrevocable trust over doing direct transfers to beneficiaries. So instead of transferring the home or the farm directly to the kids, we recommend transferring it to an irrevocable trust. The reason for that is threefold. One is you transfer that house or farm to the kids, you've literally just lost all control of that asset. An irrevocable trust doesn't do that. The second would be you transfer the house or farm to the kids. It exposes that asset immediately to their creditors. One of them gets a divorce, the other one gets into a car accident. You're potentially losing that home while you're alive. Don't want to do that. And then lastly, and it's a big one, and I think it's just oftentimes overlooked, is your children lose the step up in basis at the point you pass. So let's say you've purchased your house for $50,000, it's now worth $150,000. If you just deed that house to your kids, their basis in the house is the $50,000. So if and when they go to sell it, they're going to pay a large capital gains tax bill there. Where if the house passes through your death, it passes through probate, passes through trust administration. With this type of irrevocable trust, your kids get the date of death value rather than what you originally purchased it for. So those are the three big differences.
So with an irrevocable trust, how would somebody go about, because we do get those calls at the agency on how to pre-plan, and we do share the 5-year look back idea for them. Would that be going through an attorney such as yourself or a local attorney, wherever they are, to do so? We get some adult children that think they found their legal advice off Google and they just start transferring things and then it's already done. How would you recommend us as providers to educate families to appropriately plan for house transfers or land transfers?
Very good question. We have a blog article on this on our website. Any attorney who practices in the area of elder law should be able to set up an irrevocable trust. I just think you need to find somebody that sort of specializes in the area of elder law. So you know, the questions you ask them are, you know, how many irrevocable trusts do you do a month? How many Medicaid applications do you do a month? You know, if they're not processing the Medicaid applications, they are, you know, it's probably getting lost in translation somewhere. You know, this is something that you need to be relatively knowledgeable about. It needs to be done correctly. There's a list of attorneys in Iowa that are members of NALA, National Academy of Elder Law Attorneys. So, you know, I would like to think contacting one of them would be a good resource. I mean, we would like to think that we've got offices throughout the states and would be able to, you know, get to people. But the clients really need to be doing a little research as to who they're hiring with this type of, I mean, it's pretty specialized plan. Okay. The last bullet point is here, you know, we don't recommend life estates, which I think has been a popular planning tool, because life estates actually still have a value for that person that has the life estate interest. And it's a very high value according to a table at Iowa Department of Human Services. So we would much rather have irrevocable trust planning than life estates or the direct transfers for the reasons that I listed out. So that's the kind of proactive planning situation. The next is the crisis planning. Like I said, you know, for me personally, these are the most rewarding cases that we work on, because we find people who are in a dire situation and very stressed out and concerned about what's going to happen, and we usually come up with a really good solution. So the typical case is you're the spouse at home, you just got your first bill for $8,000, you know, what am I going to do? There are options available. So generally what people hire us to do is to advise them on the rule set for DHS, advise them on appropriate spend down items, and then we handle the application process. Because you know, getting applications through DHS, it's seemingly more complicated than you would think it would have to be. The things that we're generally recommending for them to do as far as spending down would be to pay down debt. You know, if they had a mortgage or any creditor claims, make sure the facility is paid through the month that you're targeting for eligibility. Purchasing exempt items. So one vehicle is exempt regardless of value. Prepaid funeral plans are exempt, personal belongings, the house is exempt. You know, we've had people who have, you know, a farm and they live on the farm. That whole homestead, that whole property is an exempt asset as long as somebody's living there. The last is a specialized financial product called a Medicaid compliant annuity. This is where they have the opportunity to take a large chunk of countable assets, put them into this financial product, and DHS no longer looks at it as an asset, it's just looked at as an income stream. And so now you've gained Medicaid eligibility for your spouse, you've got this chunk of assets now paying back to you, you can do with the money whatever you want to do with it. You put it right back into the investment structure that you had before. So, you know, usually people were advising them on, you know, all of these things and, you know, coming up with the best plan for them. And then, you know, don't forget about a Miller Trust. I mean, there's basically 3 eligibility requirements. You know, there's a level of care assessment that needs to be met. There is an asset test that needs to be met, and then there's an income test. And in Iowa, if your income is above a certain number, it's basically $2,250 a month. If their income is above that number, there's a requirement that there's a Miller Trust put in place. All the Miller Trust is a document that says all of your income is going to flow into this account, and then it's going to be expended on the items that DHS says that you can spend it on. But then it makes that Medicaid or the income rule disappear. Asset-wise, in order to gain Medicaid eligibility, the applicant is always going to have less than $2,000 in assets. As far as the well spouse, the spouse at home, they're going to have the lesser of $128,640 or 1/2 of their countable assets. So if I'm working with a husband and wife that have $200,000 in countable assets, the applicant's going to have less than $2,000. The well spouse, the spouse at home, is going to have less than 1/2 of that, $100,000. If I'm working with a husband and wife that have $600,000 in countable assets, again, applicant has to have less than $2,000. The well spouse is going to have less than $128,640. And then we advise them on, well, how do I go from 600 down to this 128,640? It's using those 3 techniques to be able to do that. So, you can gain Medicaid eligibility for lots of situations and people that maybe you wouldn't think could gain eligibility. Generally, with proper planning, virtually all of the assets can be preserved, kind of that point I just talked about. Not only are we trying to gain Medicaid eligibility for the client, but we're also trying to reduce any estate recovery claims. So estate recovery can only come after the assets that the applicant owns when they pass, but only after the second spouse has passed. So when done correctly, the only asset that applicant really should have in their name at the point they pass is a checking account with a few $100 in it. And so, the house should be taken out of their name, vehicles, those types of things. So that's my Medicaid discussion. Are there any questions specific to that, or?
No, that's a lot of what we do often when, like you said, like the crisis planning is we get those spouses, that their spouses in the nursing facility. How am I supposed to continue? At that point, we always refer to legal services. That's out of our world. But we understand at least the topics of the language you were speaking, so we can let them know, use this language when you're talking to the attorney. But it is important, like you said, to make sure that we're looking for an elder law specific attorney. Some will mention they know how to do it, but it just messes things up.
Right. And the unfortunate thing is, you're targeting a specific date to become eligible. You can only become eligible on the 1st of every month. Well, by the time you figure out that it was messed up, you're literally 2 or 3 months down the road.
Yep.
And that's $24,000 at the facility, or whatever the number ends up being. So it's something that you really need to have done right the first time. Mm-hmm. And so the next conversation is the VA pension. It's available for veterans. It's available for the surviving spouses of veterans. If people can gain eligibility for this, it changes how much income is going to come into the home significant. So for a vet, it's over $1,900 a month. For a vet and a spouse, it's over $2,200. For a surviving spouse, it's over $1,200. So, if you're a husband and a wife that have just moved into assisted living, between your incomes and the $2,266, you're probably going to get to a point where you can really cash flow without having to tap in further maybe to some of the assets. There's 4 different eligibility requirements. So there's a required military service test, a medical need test, an income test, and an asset test. And I'll walk through each of these. So the required military service test is 90 days of active duty. At least one of those days is during a period of war. And it's anything other than a dishonorable discharge. So the DD-214 or discharge papers, that's what's going to represent their service information. When I first started doing this, we were working with a lot of World War II vets and surviving spouses. Right now we're, Korean War and Vietnam conflict, and I just see that continuing down the line. The second test is a medical needs test. So this is where the VA is looking. Well, is there a medical need here? So they're looking at, is somebody blind or living in assisted living or skilled care, or are they needing assistance with activities of daily living? So, I tell people that if you're not receiving home care, or you're not receiving or moved into assisted living, you're not going to receive this because you're not medically eligible. But at the point you do find yourself in those situations, that's when it could potentially kick into place. It's sort of a long-term care insurance policy in your back pocket is kind of sometimes how I discuss it. The income test is just a pure math formula. This is where the VA is looking at all of your income. From that, they subtract out the unreimbursed recurring medical expenses. If that formula nets out to 0 or below, they will be eligible according to this test. So as far as what's an unreimbursed recurring medical expense, that will be your Part B premium, Part D premium, Medicare supplement, home care costs, assisted living costs, caregiver costs. So again, most of the people we work with have just moved into assisted living. So let's say it's a husband and a wife, their total incomes are $3,500 a month. Well, just the assisted living bill is $4,000. $3,500 minus $4,000, that's out to a negative number. They would be eligible according to this test. And then lastly, as an asset test, there was a huge rule change back in 2018 that did a number of things. I mean, one, it added a look-back period on the transfer of assets. So if you're trying to gain eligibility for the VA pension, if you were doing it in early 2018, you could have lots of assets today, transfer them to an irrevocable trust. For VA, they didn't care about that. Well, now they do. They've implemented this 3-year look-back period. So if you're looking at trying to gain eligibility asset-wise, there needs to be a little more pre-planning there. The nice thing that they did in 2018 was they've actually defined an asset number. Before we never really knew what the asset number was. We just kind of spent them to a low number. Well, now they've defined it as $129,094. The same types of assets that are excluded for Medicaid are also excluded for the VA pension. So a home, a vehicle, personal belongings, prepaid funeral plan. A little summary. Nobody wants to talk about these things, incapacity, death, moving into a care facility. But, planning does equal savings. One situation that is so frustrating for us is, let's say I've got somebody who's done all of the correct planning. They've got a will, they've got the POAs, they went out and they purchased long-term care insurance. Don't wait to go visit an elder law attorney until after the long-term care insurance policy is paid out. Do it right when you start receiving home care or move into assisted living. That will provide the family an opportunity to do some planning while your long-term care insurance continues to pay out. And then that's all I had.
So what options, say someone didn't pre-plan and now they have a diagnosis of a form of dementia. What options does the person have, but also what options does the family have to protect those assets, to help apply for Medicaid, all of that?
So it's a single planning case? Is that, so
right.
It's just the mom or the dad, or it's husband and the wife?
We'll keep it simple. We'll just do the one person.
Okay. Well, those are more complicated cases.
Oh, okay.
Yeah, the husband and wife case is an easier case. Let me just walk through that, okay?
Okay.
So again, our typical client is, husband and a wife. They've got their home, 1 or 2 vehicles, personal belongings. They've got a few $100,000 in checking, savings, investments, and that's kind of our typical situation. One of them moves into a care facility. So let's say they've got $300,000 in countable assets. So the first form that's sent into Medicaid is a form called the Resources Upon Entering Medical Facility form. So that effectively takes a snapshot of husband-wife's assets on the first day of the month that somebody moves into a facility, and they're expected to stay 30 days or longer. So in that situation, let's say the husband moved to the care facility, the house is going to be exempt, one of the vehicles, personal belongings, everything else is going to be countable. So it'll document all that up top. And then at the bottom, it's going to say, in order to gain Medicaid eligibility for the husband, he's going to have less than $2,000. And then the wife is going to have less than that $128,640. So, you know, when people visit us, oftentimes they're just about to move their spouse to the facility, or maybe he's been there a month. So we will know that we're targeting the first of the month to gain, of the next month to gain Medicaid eligibility. So, you know, we would advise them, you're going to have to get below 128,640. You're currently at 300. So we would walk through, you know, make sure the facility is paid through the first of next month. Do you have any other debt? Most of them don't. The next would be, you know, oh, let's say you have 2 vehicles. Well, you know, you don't need 2 vehicles because it's just you now at home. You know, let's trade the 2 vehicles in and buy 1 vehicle. Or, you know, you haven't prepaid for your funeral plans. Why don't you do that? Excuse me. Prepaid funeral plans are available for a husband and a wife. They're also available for their children and their children's spouses. You know, usually when it's a husband-wife case, usually they just do it for the husband and wife. And then the last would be, okay, in order to continue this spend down, we're going to advise you to put money into a Medicaid compliant annuity. So they effectively, you know, to go from 300 down to 128, let's say they've got to spend down, you know, about $170,000. They can put this $170,000 in an annuity that's Medicaid compliant, have it paid back really quickly. You know, you can have it paid out over 17 months, you know, $10,000 a month for 17 months. But what you've done in that situation is you've instantly gained Medicaid eligibility for the spouse in the facility. And then the spouse at home basically gets that $128,640 plus the remaining $170 or whatever the number is coming back in that annuity. So it really puts them in the same position, which is a relief that they don't literally have to spend down to nothing or go homeless when their spouse moves into a care facility. You know, I mean, we spend, you know, all kinds of money on, you know, people that have heart attacks or, you know, those types of situations on the healthcare piece, but we, you know, we haven't as a society come up with a good solution for this Alzheimer's, dementia, nursing home aspect. I mean, it's just an unfunded part of what's going on. Was that enough detail as far as kind of spend down techniques or?
Yeah, I think the spend down side of it, our struggle is trying to get to families before somebody tells them they have to spend down and now they have no money. And it's like, well, I wish somebody would have told me. Like, I wish you would have came and talked to us.
Right.
And so, and then, you know, sometimes we do have that spouse that goes into a facility. Then we have our community spouse that may have some cognitive impairments, not fully diagnosed with any form of dementia, but now they need, you know, maybe an adult child to help them with finances. So then you have this, you know, adult child that mentions, oh, let's just do a financial power of attorney. Well, the community spouse isn't quite sure what they're signing. You know, the spouse in the facility has no idea what's going on. And so that's the mess that we get involved as well. And that huge gray area when we have any kind of cognitive, you know, incapacity.
Well, and you know, I mean, we see that. I mean, you know, we as elder law attorneys or just attorneys in general are, you know, if we're preparing legal documents, we're certainly trying to evaluate capacity of the person signing. You know, if there's indications that they do not have capacity, you're really forced to put in place a guardianship conservatorship in that situation. Yeah, I mean, even in those situations, we have had success having basically a Medicaid spend down plan approved to be done for that spouse at home who is having some cognitive issues. So at least the assets still can be preserved for their potential care in the future.
Yeah, and with those new guardianship and conservative rules that, you know, just passed, that's a hard system. And that's what we usually tell people is if you don't have a power of attorney set up and now you have, you know, any concern of dementia or cognitive impairment, you know, your other option is guardianship or conservatorship, and people just don't have the money or the time to do that.
Yeah. Yeah, I mean, having the proper documents ahead of time is certainly what you want.
Right.
And yeah, we run into the situations you do as far as, you know, we're running into it a little too late, and how do we pick up the pieces and move forward from here?
Yeah. So with that, what would be some guidance for us as providers to help pick up some of those pieces when we are referring them to legal services, whatever that may look like?
Well, you know, and I don't know where everybody is at, but, you know, I think it's, you know, potentially you guys bringing in speakers and creating a network of trusted advisors that, you know, you can send people to where they know what they're talking about, because the area of elder law is relatively specialized. There's a lot of landmines to navigate, just family dynamic wise, and just substantively as far as what's going on. You know, asking those questions of the attorneys. You know, how many Medicaid applications does your law office file a month? And, you know, those types of things with more complicated planning. So yeah, it's just doing a little investigatory work.
Well, Matt, it doesn't look like we have any additional questions, so I want to thank you for your time, for joining us and be able to share your expertise and some of the extra guidance. And you know, I did take a lot of notes that I didn't already know, so I appreciate that. And it is a learning experience. So I'm glad that, you know, we have you within our state and within our area to be able to utilize your talents and your information. So thank you.
Yeah, I mean, you have my contact info. You know, if you want to share that, I'm happy to answer, you know, emails with questions and things like that.
Okay, wonderful. Well, I'm going to take back the screen, and you can, you know, certainly stay on, and we're going to talk about connections as a whole, and then we can just kind of go.
I've got an appointment after this, but thank you for having me.
Okay, thank you. So a little bit about Connections Area Agency on Aging. We do serve the 20 Southwest counties in the state of Iowa. Our goal is to enhance the quality and life of elders in our service area through education, planning, and coordination of services. We do have 3 offices in Council Bluffs, Crescent, and Sioux City in order to be able to do this. We do have a few different service areas, Healthy Living, which is normally for our, people know us for our Meals on Wheels services. We also do the senior centers. We have a couple different programs to help people matter of balance, Tai Chi, be able to stay healthy while they stay at home. We also have our community engagement program. This is going to be we have a partnership with Iowa Vocational Rehab to be able to help individuals who are older, who still want to be able to be in the workforce, but they just need that extra support. And it's educating employers that even though somebody may be, you know, 65 years old, they still have a lot of talents to be able to share with individuals, in their work ethic is there as well. We also offer our SHIP, our Senior Health Insurance Information Program, to be able to help individuals who are new or currently on Medicare to help identify what those plans are, to be able to make sure they're on the most cost-effective program. We also have our community services. This is going to be our information assistance staff. So if somebody calls our 800 number, these are the staff they're going to speak with, be able to locate appropriate resources and services and supports to help them remain in their home, and to be able to provide that care to their loved one. We also have our service navigators that would be able to do a number of things. One is going to be our options counseling, to offer the hands-on services, to be able to look at their assessment, what is their needs, and be able to help them connect to those community resources, look for those funding supports to be able to stay in their home as well. We also offer a long-term options counseling through our case management program. This is going to be ongoing. We also have some funds that can be able to help pay for some services if they need to. Could be paying for those home delivered meals. Could be, paying for a lifeline, some respite services for their caregivers, a little bit of those supports. I work in our Elder Abuse Prevention Awareness Program, and so a little bit about elder abuse is Iowa defines it as someone who harms or neglects a person who's 60 years or older. It can happen to anybody. It can happen from anybody, a caregiver, a family member, a neighbor, even a complete stranger. And it can happen anywhere, in the person's home, their relative's home, or in assisted living. There is different types of abuse, physical, emotional, sexual, financial, neglect, which could be confinement to maybe their room or a certain spot in the home, or abandonment. They just leave them at home or leave them at somebody else's home or leave them at the hospital. And then there's self-neglect when they're doing harm to themselves. So our elder abuse program with Connections is assessing, individuals who are 60 years or older, assess what their risk is and what they're needing to eliminate that risk, which could be, helping them clean up their home, getting some meals, maybe transportation. It could be, replacing an appliance in their home. Could even just be educating their loved ones on how to keep them safe. Our elder rights specialists, they would be able to do the confidential assessment intake, do that in-depth risk assessment, and then looking at what is a comprehensive plan to eliminate that risk, and then do the follow-up to make sure they're able to stay safe. Another program that we use often with our elder abuse program is going to be our family caregiver program. When we are working with individuals who have dementia or a form of dementia, oftentimes we do see our caregivers are really stressed. Thankfully, with our caregiver program, they're able to provide that information and assistance, counseling and education, and then that respite care service to help them reduce some of that stress. So caregivers can call our agency, talk with our caregivers program specialists, assess what their needs are, and then connect to those resources to help keep them supported. And our respite service, what that is paying, an agency to come in and just to give that caregiver a break. Could be on a regular basis, maybe once a week, once a month. That way they're able to socialize maybe with some friends or just go to the lake and read a book or just run some of those errands. Neglect can come in a couple ways. There's active neglect, which is when somebody is purposely neglecting somebody, failing to adhere to medical or therapy or safety recommendations. And then there's passive neglect. This is what, somebody has the inability to provide the care due to an illness, disability, stress, ignorance, immaturity, or lack of resources. Oftentimes, our caregivers, they have the best intentions that they want to help somebody stay in their home, but due to maybe a lack of education on the disease or the condition, the lack of resources, lack of support, they start to neglect somebody because they don't know there is resources available. If you are concerned about somebody who may be abused or being neglected, or even a stressed caregiver, if the person is at home, you can talk with the medical staff if you know who their doctor is. Maybe talk to the doctor's nurse or even a home health agency if you know somebody is going in. Family or friends, maybe maybe somebody who knows who they are, a support or social group that they may belong to. You can always call Connections Area Agency on Aging. We provide that guidance. We can help kind of identify what is the situation and who is the best person to call. If the person is in an apartment, maybe talking with the housing staff. And if you are concerned about somebody is in immediate danger, always call the police. Abuse can happen in facilities as well. So if you are concerned about somebody who is in a long-term care facility, nursing home, rehab, there's the licensing board or the ombudsman office, and we can get those numbers to you as well. So some specific numbers in the state of Iowa, we have the Iowa Adult Protective Services, or APS. The number is here on the screen. Also, Connections Area Agency on Aging, there is our number. Even though that we primarily serve the 20 counties, Southwest counties in Iowa, we can be able to look at resources and supports throughout the state as well. Local police, each county is going to have their own, but you can always call 911 if you are concerned about somebody. Iowa Legal Aid, if you're concerned about somebody's rights, what can you do, what can they do? And then if you're concerned about anybody being financially exploited, Iowa Attorney General's office number is there as well. One thing that we had seen or we have noticed from talking with different providers is people are asking for a way to connect with different providers, identify what is the risks, what are the services needed, and just where to go for questions. Different providers can go to different community meetings, but trying to look for a way to get everybody involved. So we had started up the WRAP Coalition, Western Iowa Region Adult Abuse Prevention Coalition. The mission is for the community awareness to recognize and report adult abuse, including neglect, financial exploitation of the adults at risk. This is open to any adult 18 and older, not just 60. And it's a time or area to be able to support professionals through education and collaboration. Be able to look at some community resources development, policy advocacy, being that needed change within our community. So we do have 3 of them within our different areas, and it is through a Google group listserv. So we do share ongoing trainings, different questions one may have. We do meet quarterly. We did initiate this before COVID, so we are looking at how do we kind of revamp this a little bit given our current circumstances. And during that time, we usually have speakers that will come in and talk about their agency and their specific program that is geared towards serving individuals who are at risk. So overall, it's just being aware that abuse does happen at all ages, speaking up if we are concerned, and then calling for help if we want to, we see something, we just don't know what to do. It's just getting that help involved for somebody who may not otherwise speak up. So it's knowing the signs of the different abuse that is out there. You speaking up and being concerned really could save somebody's life. And really important is working together as a community, be able to detect and report suspected abuse and educate our seniors and other community members on what to look for. So I do appreciate your attendance at this training as well as the other ones. And together as a community, we can be that change for our elders now and in the future. Thank you.